Welcome, and thank you for standing by. All participants will be able to listen only until the question and answer portions of today's conference. To ask a question, please press star 1. Today's conference is being recorded. If you have any objections, please disconnect at this time. I would now like to turn the conference over to Commissioner Scott LeCan. Sir, you may begin.
Thank you. Good afternoon and good morning to those of you on the West Coast. If you didn't know, I'm Scott LeCan, the Commissioner of the Office of Child Support Enforcement, and I'm very pleased to welcome all of you as we kick off the national 6-part training series on interstate case processing. We are pleased to offer these trainings to you, our state partners, and hope you will find the webinars and training resources effective and useful. As you will see on the next slide, the series covers important topics in interstate case processing from basic to more advanced. It looks like a great schedule, and I know you will learn a lot. We have been delighted by the response to this series, and as of today, we've actually had over 1,000 people registered for this first webinar. Our thanks to many of you who are gathering to listen on the webinar in rooms, and it helps us save on our resources. Finally, thank you for the hard work you do every day to serve families, including the families involved in interstate cases. Please let us know how OCSE can further support you. And now, I will turn it over to our presenters for today's webinars and for the series, Diane Potts and Jeanette Savoy. Diane and Jeanette are experienced interstate professionals and trainers, so you are in great hands. Diane?
Thank you, Commissioner LeCan. Welcome to Interstate 101 training. This training is on interstate child support case processing and will introduce and describe federal laws, federal regulations, and the Uniform Interstate Family Support Act, which is regularly referred to as UIFSA. Interstate 101 is basic training and has several companion courses on interstate case processing, including Interstate 201 training with more advanced materials on the laws and processes for interstate cases, interstate case scenarios, interstate payment processing, interstate case closure, and interstate tools and resources. All of these trainings are intended to complement, rather than repeat, OCSE's training on international case processing and the training on revised intergovernmental forms. But the concepts of those trainings will be incorporated as much as possible here. In this training, we will cover the terms regularly used in interstate cases, the history of UIFSA, basics of interstate cases, establishment of parentage and support orders when parents live in different states, enforcement across state lines, and modification of support orders. During this 90-minute training, there are 3 breaks for questions and 1 final opportunity for questions at the end of the training. You may type your question into the Q&A box on WebEx or wait until a break for the operator to unmute the phone lines. This training references the actual laws, regulations, and policy guidance being discussed today, such as UIFSA. At the end of the training, there is a list of those materials with hyperlinks to the electronic version of those documents. And now I'll turn it over to Jeanette.
Good morning and good afternoon, everyone. So before we begin, just one quick note. Throughout this training, we are going to use the term parent because most child support cases involve 2 parents. It's important to recognize, though, that some child support cases may not involve 2 parents, such as when the child's guardian or a foster care agency is the party seeking support. The same interstate rules apply in those cases when it's not the actual parent of the child pursuing support. Now, let's go ahead and look at some of the terms used in interstate cases. The next 3 slides list the common terms used for different types of child support cases. An intrastate case involves only one state. In most intrastate cases, both parents live in that state that is providing child support services. When parents live in different states, many child support professionals refer to the case as an interstate case as opposed to an intrastate case. But there are other terms that we will learn in this training that more accurately describe the type of interstate case. One-state remedies involve one state taking action against a parent who lives in or has income or assets in another state. In contrast, an interstate 4D case encompasses two states. Hence, it is commonly referred to as a two-state case and involves one state referring a case to another state for specific child support services. In most cases, an interstate 4D case is a referral from the state providing services to the custodial parent to the state where the non-custodial parent resides. In this training, we are going to talk about both one-state remedies and interstate 4D cases. An international case involves at least one foreign country. For example, one parent may live in Italy and the other parent and child live in Delaware. OCSE has 9 training modules devoted to international cases under the new Hague Child Support Convention on its website. And because there's already extensive training on international cases, we are not going to focus on cases involving foreign countries in this interstate training series. But you should be aware of some basic things. First, UIFSA requirements apply to all states in all incoming cases, including international cases coming from a foreign country. Second, while UIFSA applies in every state to incoming international cases, foreign countries, of course, do not have UIFSA for outgoing international cases from the U.S. Finally, not every country meets the definition of foreign country under UIFSA. For example, China would not be a foreign country under either UIFSA or federal regulations for purposes of child support enforcement because China has not ratified the Hague Convention and does not have a reciprocal agreement with the U.S. The term intergovernmental 4D case is defined by federal regulations as a 4D case in which the non-custodial parent lives or works in a different jurisdiction from the custodial parent and child, and the case has been referred by an initiating agency to a responding agency for services. An intergovernmental 4D case may include any combination of referrals between states, tribes, and foreign countries. For example, an interstate 4D case could be when one parent applies for services in Oklahoma and a case is sent to a Cherokee Nation reservation where the other parent resides. Or one parent receives TANF in Arizona and a case is referred to Oklahoma for enforcement against the other parent. Or maybe it's one parent applies for services in Arizona and a case is sent to Germany where the other parent lives. It's important to know the formal term intergovernmental 4D case and its regulatory definition, although informally you may hear the term simply as intergovernmental case. Also, intergovernmental case may be used as a generic term encompassing all kinds of interjurisdictional cases. Now I'm going to turn you back over to Diane.
Thanks, Jeanette. Here are some additional terms that will be used during this training. The term issuing state refers to the state where the child support order was issued. As you will see during this training, the issuing state may change if the original child support order is modified by another state. Child support professionals often use the terms custodial parent for the person receiving child support and non-custodial parent for the person paying child support. These terms are used in federal law. UIFSA, on the other hand, uses the term abogee and abogor in order to emphasize who has the support obligation. Your state may use other terms for parents in the 4D program. For simplicity, this training will use the terms custodial parent and non-custodial parent. But OCSU recognizes that there are cases where the parents have shared custody. Also, remember that some cases involve a guardian of the child or a foster care agency and not an actual parent. The same rules apply in these cases as well. Another common term used in federal law to refer to the state child support agency is 4D agency. As you may know, 4D is the section of the Social Security Act that created the federal, state, tribal child support program and contains the required laws on child support. The 4D agency administers the 4D program in the state. UIFSA uses a similar but broader term, support enforcement agency, which includes the 4D agency, other state or local governments, and certain private agencies responsible for establishing, enforcing, and modifying child support and or spousal support orders. Each state 4D agency has a central registry that processes incoming intergovernmental cases and checks to see if incoming cases have all of the required documentation, and if not, requests missing information. The central registry then will send the case for location services or to the local office for administrative or judicial action. The central registry also is responsible for responding to inquiries from other states, tribes, and foreign countries.
Federal regulations use the terms initiating agency and responding agency for intergovernmental cases. An initiating agency is the 4D agency where a parent has applied for or is receiving services and includes an agency in a foreign country. These services may include referring an intergovernmental case to a responding agency. The responding agency is the 4D agency taking the establishment, enforcement, or modification action that was requested by the initiating agency in an intergovernmental case. In most cases, the initiating agency will be providing services to the custodial parent, and the responding agency will be in the state where the non-custodial parent resides or has income and assets. But there certainly may be instances where the non-custodial parent has applied for services in an initiating state, such as when a modification of support is needed. In that case, the initiating state will send the case to the responding state where the custodial parent resides. UIFSA defines tribunal as a court, administrative agency, or quasi-judicial entity authorized to establish, enforce, or modify support orders, or to determine parentage of a child. Depending on state law, a tribunal may include the support enforcement agency. Now let's practice using the terms covered so far in this training. Here we have one parent living in Arizona, the non-custodial parent, and the other parent living in Texas with the child, the custodial parent. If the custodial parent applies for services, the 4D agency in Texas, of course, must open a case and then determine the most appropriate case processing option. If the 4D agency in Texas decides to use its one-state remedies, it will seek to establish the support obligation for the non-custodial parent directly without involving Arizona. If the 4D agency decides to send an interstate 4D case to Arizona, Texas will be the initiating agency and Arizona will be the responding agency. Arizona will then seek to establish a support obligation for the non-custodial parent. Arizona's central registry will receive the case and check to make sure that all the required documentation is included before sending it on to the appropriate office or unit in the state to proceed with whatever Texas has requested, be it establishment, enforcement, or modification. Later in this training, we're going to look at each action, establishment, enforcement, and modification individually.
Now that we have the terms down, let's briefly discuss the history of UIFSA. UIFSA was developed by the Uniform Law Commission in 1992 to provide a comprehensive body of law for interstate child support cases, which replaced the prior model acts. In 1996, the Commission amended UIFSA, and about a month later, Congress mandated that all states enact UIFSA by 1998 in order to remain eligible for federal funding of their child support programs. Uniform Law Commission subsequently amended UIFSA in 2001 and 2008, which resulted in different states having different versions of UIFSA. However, in 2014, Congress mandated that all states enact UIFSA 2008, resulting in a uniform law in all states. Now that all states have enacted UIFSA 2008, this training simply will refer to UIFSA for the 2008 version. UIFSA can be found on the Uniform Law Commission's website, and the hyperlink is contained at the end of this training. UIFSA provides one set of rules for states to follow for interstate child support cases and facilitates interstate coordination and cooperation. And UIFSA has made a difference. In 2016, interstate child support collections totaled almost $1.6 billion. OCSE has issued policy guidance on UIFSA, including IM 1602, as a resource for states. Like most uniform laws, UIFSA is divided into articles by subject matter. For example, Article 3 of UIFSA contains many procedural rules for UIFSA proceedings and is titled Civil Provisions of General Application. Each article contains a number of sections, and each section sets forth a specific principle of law. Most sections also have a comment that helps tribunals interpret the law by providing explanations for the specific section and any changes from prior UIFSA versions. It's very important to look at both the applicable UIFSA section and the comment when questions arise about UIFSA. Here, Section 318 allows a tribunal to request assistance with obtaining evidence from a tribunal in another state. The comment to Section 318 explains that this section takes a logical step to facilitate interstate and international cooperation by enlisting the power of the forum to assist a tribunal of another state or country with the discovery process.
Now, let's move on to the basics of interstate cases. Title 4D of the Social Security Act and federal regulations establish the framework for 4D agencies to follow when working intergovernmental cases. Federal law requires states to cooperate when handling interstate cases and gives states a financial incentive to do so. In an interstate 4D case, both the initiating and responding agencies can count the child support collections when calculating federal financial incentives. Federal law also requires states to enact UIFSA 2008, and all states have done so, as Diane mentioned. Finally, federal law requires each agency to have a central registry to process interstate cases. Unlike UIFSA, which applies regardless of whether or not a 4D agency is involved in the interstate case, most requirements in Title 4D of the Social Security Act and in federal regulations apply only to open 4D cases. The Federal Full Faith and Credit for Child Support Orders Act is called FFCOA for short. FFCOA was enacted in 1994 and requires courts of all U.S. territories, states, and tribes to give full faith and credit to a child support order issued by another state or tribe that had jurisdiction over the parties. FFCOA was designed to be consistent with UIFSA. While tribes are not required, like states, to enact UIFSA, they are required to abide by FFCOA. So both states and tribes apply the same rules regarding continuing exclusive jurisdiction and modification jurisdiction determining the controlling order, and choice of law, concepts that we'll cover in this training and also then in the Interstate 201 training. OCSE also has issued guidance on FCSOA, and that's in AT 0203 for both states and tribes. A link to FCSOA on the OCSE website is at the end of this presentation. Let's move on now to UIFSA basics. Although they are not the same, UIFSA and federal law work together to provide structure for 4D agencies to follow when working intergovernmental cases. Most provisions apply regardless of whether or not the 4D agency is involved in the case. Before UIFSA came along, the majority of support proceedings were what we call de novo. That meant that even when an existing order of one state was sent to a second state for registration and enforcement, the second state often asserted the right to issue a new support order. This resulted in multiple support orders in effect in several states. UIFSA was designed to prevent this problem by having a one order at one time rule combined with limits on how the power of tribunals to modify existing orders. If a state with jurisdiction under UIFSA enters a support order, that state is the issuing state with the order that controls the child support obligation, commonly referred to as the controlling order. Until that order is modified by another state, the order will continue to be the controlling order, and the state is the issuing state even after the parents and child have left that state. Under UIFSA, the initial controlling order will determine the duration of support. For example, let's assume that the initial controlling order is set by New York, and New York law provides that parents are obligated to support their children until age 21. Any future modification of that order under UIFSA, therefore, will maintain that duration even though the law in the state modifying the order has a different age at which child support terminates. All states must recognize the controlling order and, upon request, must enforce the controlling order. It does not matter if both parents and the child have left the issuing state, that order remains enforceable. The concept of registration is very important. A state often will enforce an order by registering it, which entails filing the controlling support order with a tribunal. Once the order is registered, it may be enforced in the same manner and is subject to the same procedures as an intrastate order.
Continuing exclusive jurisdiction is a core concept of UIFSA and defines which state has the authority to modify the controlling order. It is commonly referred to as CEJ. CEJ maintains the one order at one time rule. Under UIFSA, a state with CEJ has exclusive authority to modify a child support order in an interstate case. We will look at the UIFSA modification rules later in this training and in Interstate 201 training. But for now, it's important to know the basic CEJ rule. The issuing state will retain CEJ to modify its order as long as a parent or the child resides there, unless the parents consent otherwise. To apply these UIFSA basics, let's consider a hypothetical case. The issuing state is Minnesota, and the custodial parent and child continue to reside there. The non-custodial parent has moved to Wisconsin. In this example, Minnesota has CEJ because the custodial parent lives there. If one of the parents wanted to modify the controlling order, the tribunal in Minnesota has the exclusive power to modify the order, unless the parents consent otherwise. This is because one of the parents continues to reside there. It doesn't matter if it is the custodial or non-custodial parent who is seeking the modification. Finally, Minnesota can enforce its order, but remember, under UIFSA, any state can enforce the order upon request. The 40 agency in Minnesota can use one state remedies and initiate a direct income withholding notice to the non-custodial parent's employer in Wisconsin. The other option is that the Minnesota 40 agency can initiate an Interstate 40 case to the 40 agency in Wisconsin. Wisconsin, as the responding agency, will enforce the order against the non-custodial parent's income and assets in Wisconsin. Because the laws prior to UIFSA made it possible for more than one state to have a child support order for the same non-custodial parent and child, UIFSA contained a procedure for a tribunal to determine which order was controlling. The procedure, called Determination of Controlling Order, or DCO, is set forth in Section 207 of UIFSA. Since UIFSA has been in effect for 20 years now, there should not be more than one valid support order. This procedure, therefore, is rarely used today. So before we move on to interstate establishment, are there any questions on interstate terms, history, or basics?
You may type your question in the Q&A section on your computer or ask them over the phone. So, operator, would you please open the lines?
Thank you. If you would like to ask a question, please press star 1, and you will be prompted to record your first and your last name. Please unmute your phone when recording your name, and to withdraw your question, press star 2. One moment.
We'll give people a moment here to decide if they're going to ask a question.
We do have a question from Henrietta. Your line is open.
Can you tell us what FISOLA is again? What does it mean?
I'm sorry, would you repeat that, please?
FISOLA.
Jeanette, the question is, what is FISOLA?
Oh. Go ahead, Diane.
Okay, sure. So FISOLA is a federal law that Congress passed in order to ensure that all states give full faith and credit or recognize child support orders of other states. The tribes are governed by FISOLA, as are the states. Does that answer your question?
Yes, thank you.
And we do have a few questions on the Q&A. It looks like several of them are about who can modify, and we're going to go into that in more detail. Okay? And there's a question that says, why is tribunal rarely used? No, tribunal is used. What is rarely used is the determination of controlling order. Do we have any more on the phone at this point?
We do have another question on the phone. We have Ashley Ledbetter. Your line is open.
Yes, hi. I'm from Louisiana, and our question is, if we know multiple orders are not supposed to be issued under UIFSA, but if that should happen, are we then to do a determination of controlling order?
So I'll take a stab at that. This is Diane. If you have orders from different states, yes, the determination of controlling order provision is applicable, and you should use it and bring it before the tribunal to make a determination of which is the controlling order among those states' orders.
Diane, I guess I would respond to that a little differently. If those orders were issued after 1994, which I'm presuming at this point, I say, yes, you need to determine which order is valid, but I would not encourage you to use the determination of controlling order procedure, because you might end up determining that the invalid or the second order that should not have been issued would be the controlling order. So you do need to get, I would say you do need to get it in front of a tribunal to determine which is the valid order to enforce. What do you think, Diane?
So it's a very rare provision, and it's I guess it's a little curious that if you are seeing a lot of cases in which you've got multiple orders from other states, that may be something that should be brought to the attention of your OCSC regional person.
We did see this a lot when I worked in the Central Registry in Colorado, and I truly think it's just because the second state wasn't aware of the order in the first state. So it's not, like I said, it's not really a controlling order. It's that the second order is void or voidable. Do we have other phone questions?
That was our last phone question.
Okay, we have a couple more on the Q&A. One is, are the terms interstate and intergovernmental the same? Well, they're very often used interchangeably, but when you talk interstate, you're really only talking about a case between two states, and the intergovernmental is to also include tribes and other foreign countries. And one last one we have is, if UIFSA applies to all incoming international cases, does that require foreign countries to provide UIFSA documentation? I'm sure this is covered in the international training, but the quick answer that I would give is, they will not necessarily use our federal forms, but if you have the information you need, then you would proceed. So I think in the interest of time, we are ready to go forward. And if you have other questions, of course, we'll have a few more sessions of questions, and we'll take questions at the end if we have time. So let's move on to establishment principles. In this training, we'll focus on establishment in interstate cases. However, establishment in other types of intergovernmental cases, such as international cases, is similar. It just varies slightly. UIFSA allows for 3 types of establishment: parentage, child support, and spousal support. If there's been no support order entered for a child and non-custodial parent, UIFSA allows a tribunal in a state that has jurisdiction to enter a child support order, and that becomes the issuing state with the controlling order. Once a tribunal with jurisdiction issues a child support order, no other tribunal may issue a new support order. If parentage has not been established, either pursuant to law or determined by a tribunal, UIFSA also allows a tribunal to enter a judgment of parentage. And finally, UIFSA permits a tribunal to establish spousal support, although that litigation does not fall within a 4D agency's responsibilities, and therefore we're not going to cover it in this training. A 4D agency providing services to a custodial parent has 2 options if parentage or support or both needs to be established, and the non-custodial parent lives in a different state. The first option is for the 4D agency to use one-state remedies through what's called long-arm jurisdiction to establish support or parentage against the non-custodial parent. The second option is for the 4D agency to refer an interstate 4D case to the 4D agency in the state where the non-custodial parent resides. Please note that sometimes the non-custodial parent is the one receiving 4D services. In that case, the 4D agency may refer an interstate 4D case for establishment to the 4D agency in the case where the custodial parent resides. The one-state remedy option is available only if certain criteria are present, which we'll cover in the next few slides. The interstate 4D case referral is always an option.
In order for a tribunal to have the power to require an individual to take an action, such as pay child support, the tribunal must have personal jurisdiction over the individual. A tribunal has personal jurisdiction over a person who lives in the state. Sometimes, however, a tribunal will be able to exercise personal jurisdiction over a non-resident. so long as that individual has minimum contacts with the state. This is called long-arm jurisdiction because the tribunal is reaching out and obtaining personal jurisdiction over a person residing in another state. The concept of long-arm jurisdiction stems from constitutional requirements of due process. Federal regulations require a 4D agency to consider using long-arm jurisdiction to establish a child support order if the agency determines that long-arm jurisdiction is both available and appropriate. In the illustration on the slide, the tribunal in Texas is extending its arm to assert personal jurisdiction over the non-custodial parent in Arizona, which is allowed so long as that parent took certain actions in and had contact with Texas. If so, Texas may be able to enter a child support order and, if needed, a parentage judgment against the non-custodial parent. We'll see on the next slide what sorts of actions will subject a non-custodial parent to the jurisdiction of a tribunal in another state. Section 201 of UIFSA lists the actions that will subject a non-resident parent to the jurisdiction of a tribunal in another state. The first action is if the non-custodial parent is served with a summons, or if state law permits with a notice or citation, to appear in court while he or she is actually in the state. Using our example from the previous slide, if the parent is served with a summons while he or she is actually in Texas, the Texas tribunal will have long-arm jurisdiction to establish support and, if needed, parentage. The second action is where the non-custodial parent consents to jurisdiction. Allowing parents to consent is consistent throughout UIFSA. As you will learn later in this training, parents may consent in a record to a tribunal's jurisdiction outside of the standard UIFSA modification rules. Under UIFSA, if the parent resided in the state with the child, a tribunal will have jurisdiction to enter a child support order and, if needed, a parentage order. The joint residence could have been in the past. Again, using our example, if the non-custodial parent lives in Texas with the child at any point, Texas will have long-arm jurisdiction to establish a support order against the parent for the child. Another basis of long-arm jurisdiction, if the non-custodial parent lived in the state and provided prenatal expenses to the mother or support for the child, then he or she will be subject to support proceedings in that state. Section 201 of UIFSA lists 3 other specific actions by a non-resident that can be the basis of personal jurisdiction. The tribunal has jurisdiction if the child is in the state because of acts or directives of the non-resident parent. A common example is if the custodial parent and child move to the state to avoid domestic violence by the non-custodial parent. Another example is where the non-custodial parent tells the custodial parent to go live with the non-custodial parent's relative. The action listed as number 6 refers to where the conception may have occurred in the state. This is a common basis to assert personal jurisdiction, and the reason why many states ask where the sexual relationship occurred on a paternity affidavit or questionnaire. The test is whether the conduct was during the probable period of conception. The last specific action involves a non-resident asserting parentage in a putative father registry. States did not have to enact this subsection of UIFSA because not all states have putative father registries. Section 201 of UIFSA also contains a broad provision that will allow a tribunal to assert long-arm jurisdiction using any basis consistent with the U.S. or state constitution. Finally, it's important to note that even though a state may have long-arm jurisdiction over a non-resident parent under the facts of the case, the parent still must be served with the legal documents. Sometimes it may be difficult for an out-of-state 4D agency to serve the non-custodial parent in another state, which may lead to the referral of an interstate 4D case instead.
There are substantial benefits to a state exercising long-arm jurisdiction when the facts establish that the non-custodial parent had the requisite contact with the state. If a tribunal in your state exercises long-arm jurisdiction over a non-resident, the tribunal will apply your state's laws to determine all of the relevant substantive issues. This means that child support will be calculated according to your state's guideline, and your laws will determine any other issues. Another benefit is that the order will be the initial controlling order in the case, so duration of the support obligation will be governed by your state's laws. As long as a parent or child resides in your state, then you, as the issuing state, have CEJ to modify the order. UIFSA allows a tribunal exercising personal jurisdiction over a non-resident to enlist the assistance of a tribunal in that parent state. Such assistance may include help with a deposition or providing a location for testimony by telephone or other electronic means. Tribunals can communicate with each other about laws, the legal effect of an order, and the status of a proceeding. UIFSA also authorizes the tribunal establishing the order to ask the tribunal in the non-custodial parent state to help with discovery. If the non-custodial parent fails to cooperate, the assisting tribunal may compel the parent to comply with the discovery order that was issued in another state. UIFSA was designed to accommodate the presentation of evidence across state lines. First, the non-resident parent is not required to be physically present in a tribunal in order for a support order to be established. Instead, the tribunal may consider evidence, such as an affidavit or documentary evidence transmitted by electronic means, when setting the support order. And second, the tribunal must permit the non-resident parent to testify under penalty of perjury by telephone, audiovisual, or other electronic means at a designated tribunal or other locations, sometimes at the child support office in his or her state.
Now let's go back to the illustration. Assume the parents lived together in Texas when the child was conceived. They signed an acknowledgement of paternity for the child at the hospital and continued living together for a short time after the child was born. Under UIFSA, there are several provisions under which Texas may exercise long-arm jurisdiction. First, under UIFSA Section 201A3, a tribunal in Texas may exercise long-arm jurisdiction over the father because he lived in Texas with the child. Under Section 201A5, the tribunal may exercise long-arm jurisdiction because the father resided in Texas and provided support for the child. Under Section 201A6, the father is subject to jurisdiction in Texas because the child was conceived there. Finally, because the father signed an acknowledgement of paternity in Texas, a tribunal likely would determine that the father had minimum contacts with Texas, sufficient for jurisdiction consistent with the state and federal constitutions. Therefore, the 4D agency providing services to the custodial parent may file a case to establish support in Texas and serve the non-custodial parent with the establishment petition and any other necessary documents in Arizona. Once served, the non-custodial parent must participate in the proceedings in Texas or risk having a default order entered against him. Remember that the parent does not have to travel to Texas to participate, although he certainly can appear personally. The parent instead may testify under penalty of perjury at a tribunal in Arizona or other designated location, and he may submit evidence in the form of an affidavit or documents submitted electronically, such as a W-2 form or paycheck stubs. The tribunal in Texas will set the support order in accordance with the Texas Child Support Guideline, and Texas will be the issuing state with the controlling order under UIFSA. As long as any party or child resides in Texas, Texas will continue to have CEJ for purposes of modification.
The other option that is always available to the 4D agency in an interstate establishment case is to refer the case to the 4D agency in a state with personal jurisdiction over the non-custodial parent. Usually, this means referring the case to the state where the non-custodial parent resides. The interstate 4D case referral is always an option if the state providing services to a parent does not have long-arm jurisdiction over the other parent, or one state remedies are not appropriate or were not successful. This slide lists the required federal intergovernmental forms that must be sent by the initiating agency on an interstate 4D case to establish child support. And they include the Child Support Enforcement Transmittal Number 1, the Uniform Support Petition and General Testimony, and the Child Support Agency Confidential Information Form and the Personal Information Form for UIFSA Section 311. The last form, the Personal Information Form, contains all of the information required by Section 311 of UIFSA, including the names, addresses, and Social Security numbers of the parents, and the name, gender, address, Social Security number, and date of birth of each child for whose benefit support is sought or whose parentage is to be determined. Please note that the responding agency may require additional documents for child support establishment, such as the custodial parent's pay stubs or tax returns when necessary to establish an order. UIFSA allows the forms listed on the prior slide for interstate child support establishment to be sent electronically. In OCSE's Interstate Tools and Resources training later in this series, we'll discuss OCSE's interstate communication tools that may be used to help process interstate cases, including the electronic document exchange. The forms required for an interstate 4D establishment case, as well as other types of interstate cases, are listed on a matrix OCSE developed. And as we've mentioned, you'll find the link to the matrix at the end of this presentation, and it is available on OCSE website. Also on its website, OCSE has training materials on filling out the forms listed in this training and explains which forms are intended to provide information for the responding agency only and which are intended to be filed with the tribunal. If parentage has not been established, either by law, acknowledgement, or order, the initiating agency must also request that the responding agency establish parentage as part of the interstate 4D case. The intergovernmental forms listed on this slide apply to parentage establishment and include, again, the Child Support Enforcement Transmittal Number 1 and Uniform Support Petition, the Declaration in Support of Establishing Parentage, and remember that you need one for each child, the General Testimony, and the Child Support Agency Confidential Information Form, and again, the Personal Information Form for UIFSA Section 311.
Once the initiating agency has completed the required documents, the Interstate 4D case is sent to the applicable central registry. Federal regulations require the central registry to process the case within 10 working days, including determining if the case file is complete with all required documents, and if necessary, asking the initiating agency for additional documentation, acknowledging that the case was received, and forwarding the case either for location services or to the local office to take action to establish support or parentage, or both. Federal regulations require the responding agency to accept and process the interstate case, regardless of whether the initiating agency had the ability to use long-arm jurisdiction over the non-custodial parent. The hyperlink to the federal regulations for interstate cases set forth in 45 Code of Federal Regulations 303.7 is provided at the end of this training. Federal regulations list the duties of a responding agency in an Interstate 40 case. As discussed, the responding agency must accept and process the case to the extent it can, even while following up with the initiating agency for additional documentation or information. The responding agency must treat the case as it would an intrastate case and provide services requested by the initiating agency and necessary to the case. In most cases, the responding agency will ask a tribunal to establish a support order and, if necessary, parentage. The tribunal will apply the laws of its state to determine these issues. Remember that UIFSA defines tribunal as including both courts and administrative agencies. Finally, according to federal regulations, the responding agency is responsible for any costs in the case. For example, if parentage needs to be established and genetic testing is requested by the non-custodial parent, the responding agency must schedule and pay for the testing. Let's look at an example. If Texas does not have personal jurisdiction over the non-custodial parent or decides that long-arm jurisdiction is not the most appropriate service for this family, Texas will send an Interstate 40 case to Arizona. The 40 agency in Texas is the initiating agency, and the 40 agency in Arizona is the responding agency. The Interstate 40 case from Texas will go to Arizona's Central Registry, located in Phoenix. The Central Registry will review the interstate packet and request any additional necessary documents or information. Even if additional documents are requested from the initiating agency, the Central Registry must go on and send the case to the appropriate office, again, either for locator services or for establishment services. In our example here, if the Central Registry determines that the non-custodial parent lives in Coconino County, the Central Registry will send the case to the office that handles cases in that county. The local office will file the case with the county superior court. Once the sheriff or other process server serves the non-custodial parent with the legal documents, the court may hold a hearing to decide the amount of child support pursuant to the guideline in Arizona. Arizona law will determine other substantive issues as well. Arizona will be the issuing state, and as we will discuss later in this training, Arizona will have CEJ to modify the order as long as a parent or child resides there. While the most common scenario is that the non-custodial parent continues to reside in Arizona, the custodial parent could move to Arizona, and the non-custodial parent could move away. It's the presence of either parent or the child that counts for CEJ purposes under UIFSA. So before we move on to interstate enforcement, are there any questions on interstate establishment?
And again, operator, would you open the phone lines, please?
Thank you. Once again, to ask a question, please press *1.
We do have a question on the WebEx that reads, so the signing of the acknowledgement of paternity does not meet the criteria for long arm. However, it gives evidence of minimum contact, right? Actually, that final number 7 in the long arm, which is does it meet any of the constitutional requirements? That's, I think, what this would fall under. The court might say that because the person signed the acknowledgement of paternity, that gives minimum contact and the long arm could be used. So do we have any phone questions yet?
Yes, our first question comes from Mary Ellen Emery. Your line is open. Mary Ellen, if you'd like to hit your mute button. We'll move on. Our next question comes from Amanda. Your line is open.
I had 2 questions regarding the UIFSA documents. You had indicated, and I know it's on the matrix, the transmittal 1. Are you also including the acknowledgement page when you reference that on the matrix?
The answer is yes.
Okay.
But actually, the acknowledgement page is generated by the responding agency.
Right.
Okay, because we weren't given clear directive on that. So when we initiate a case, whether it's paternity, establishment, or enforcement, we're only sending the initial request and not the acknowledgement page?
Correct.
So the acknowledgement page will come back to you after the responding agency gets the case, and that's how you know they've received it. Okay,
because in the past, the previous time, we would send the initial, the T1 request, and it automatically included the acknowledgement. So is that why they were separated? So now that only the responding state uses the T1 acknowledgement?
So, Jeanette, I'm going to let you're an expert at these forms.
Yeah, the forms work group decided that it would be easier and probably more efficient for the responding state to generate it, because then it can generate it from its system and not have to manually fill out a form that came from the other state. So they were separated on purpose, yes.
Oh, okay. And then my other question is for paternity and establishment. I just need clarification. The confidential form and the personal 311 form, they look exactly the same and has the exact same information. So the confidential form just for the caseworker, and the personal 311 form, is that more for the case itself when it gets referred to that state's attorney's office, or what's the difference between them, because they're pretty much the same?
You want me to take that one, Diane? Yes, the form for the 4D agency actually has more information than the 311 form, because it has employer and quite a bit more information, and it is designed only to be handled by the 4D agency. So yes, although there is a lot of similarity, we had to create a form that went to the court to fulfill that UIFSA Section 311 requirement.
Oh, okay.
Okay. So let me look at some of the questions here coming in online. Let me back up here a little. So one question is, are we correct in thinking that UIFSA also provides establishment of medical-only and paternity-only requests? Yes, you are correct, although I believe that the paternity-only is really for in-state, intrastate cases. The next question is it the duty of the responding agency to pay the costs of a review and modification? This actually sort of depends upon the states. There are some states that do charge a fee to the requesting party to do a review, and you can find those fees on the Intergovernmental Referral Guide called the IRG, which I hope that you're familiar with, on the OCSE website. In most cases, the responding agency takes care of it, but there are certain states that do charge a fee. Hopefully that answers that question. Let's see, do we have any more questions on the phone?
Yes, our next question comes from Nicole. Your line is open.
Yes, to go back to the central registry that you brought up, I just need to confirm. So when the central registry receives the packet from the other state, it is the central registry's responsibility to make sure all the required documents are in that packet, and if they aren't, then to contact that state to request the missing information, or is that up to the county or regional office to make that request?
So that is in the federal regulations, that the central registry has the primary responsibility to get the case at its location and to review the case to make sure that it has all the required documentation. That's not to say that if it goes on to a local office for establishment, that local office may identify something missing. But I think to answer your question, it's yes, it's the central registry's primary and initial duty to do that.
Okay, thank you.
And at this point, again, in the interest of time, we do have several other questions on the QA, and I'm not sure if we have others queued up on the phone, but in order to get through all of the information, we're going to move forward, and then we'll have an opportunity with whatever time we have left to answer questions at the end. So we have 2 topics left to cover, and next we're going to look at interstate enforcement of support orders. Remember that a key component of UIFSA is that once a support order is legally established in the issuing state, all states have the authority to enforce the order. The issuing state's order will remain in effect until it's fully complied with or is modified under the rules of UIFSA. As we discussed earlier in the training, a tribunal has personal jurisdiction to establish and enforce a support order if a parent lives in the state. A tribunal also will have personal jurisdiction to take certain enforcement actions against a non-resident parent, such as holding the parent in civil contempt for willfully not paying support, if that parent has minimal contacts with the state. In contrast, under UIFSA, any state may send an income withholding notice because that enforcement action does not require any type of personal jurisdiction over the non-custodial parent. Also, as covered in detail in the OCSE international training modules, a support order from the U.S. can be enforced in certain foreign countries under the Hague Convention and other international agreements. In similar fashion, a support order from certain foreign countries may be enforced in the U.S. under UIFSA. Under UIFSA, a tribunal that has issued an order will continue to have jurisdiction to enforce the order as long as it is the controlling order and has not been modified. When the non-custodial parent lives in a different state, the 4D agency in the issuing state has 2 enforcement options. The first option is for the 4D agency to use one-state remedies, which we'll discuss in a moment. And the second option is for the 4D agency to refer an interstate 4D case to the 4D agency in the state where the non-custodial parent resides or, again, has income or assets. This interstate referral option also is always available under UIFSA. It's up to the issuing state to determine whether the one-state or two-state enforcement option is the most appropriate under the facts of the case. While a 4D agency receives no federal funding to establish a spousal support order, the agency may enforce a spousal support obligation along with child support when both child and spousal support are part of the same order, such as a divorce judgment.
Let's first discuss enforcement using one-state remedies. Income withholding is one of the most effective ways to collect child support and accounts for 75% of the child support collected in the United States. The process is simple. An income withholding notice is sent to the non-custodial parent's employer. The employer deducts the child support from the parent's paycheck and then sends the support to the designated state disbursement unit, or SDU. The term direct income withholding is a specific type of withholding. Direct income withholding occurs when the 4D agency sends an income withholding notice directly to an employer in another state without requesting the assistance of the other state's child support agency or tribunal. Direct income withholding is a core enforcement technique under UIFSA and federal law. When an employer in another state receives the notice, it is required to comply as if the income withholding notice had been issued by a tribunal in the employer's state. Direct income withholding is used against the income of a non-custodial parent. Therefore, personal jurisdiction over the non-custodial parent is not required. But where there is more than one state trying to enforce an order, states must work together to make sure that there are not duplicative or competing income withholding notices from more than one state. Like intrastate income withholding, all direct income withholding orders must be on the form that has been approved by the Federal Office of Management and Budget, OMB. The more complicated issues concerning direct income withholding in the context of interstate payment processing will be covered in our interstate payment processing training later in the series. So let's look at an example of how direct income withholding works. Here, Texas is the issuing state, and the custodial parent and child continue to reside there. The 4D agency in Texas decides to use one-state remedies to enforce the support order and sends a direct income withholding notice to the non-custodial parent's employer in Arizona. Unlike an interstate 4D case, the 4D agency in Arizona is not involved and does not open a 4D case. Under UIFSA, the employer must comply with Texas's income withholding notice, withhold the child support from the non-custodial parent's paycheck, and send the child support over to Texas. Direct income withholding is very effective if the 4D agency is able to identify an employer for the non-custodial parent in another state. If an employer is located in Arizona, Texas will be able to collect child support owed to the custodial parent through direct income withholding without ever involving the Arizona 4D agency. Also remember that for direct income withholding, it doesn't matter if Texas is the issuing state or whether the non-custodial parent has had any contact with Texas, because Texas does not need personal jurisdiction over the non-custodial parent under UIFSA. But what if Texas can't locate an employer in Arizona? Then Texas's ability to use other one-state enforcement remedies will depend on whether the non-custodial parent has any income or assets in Texas. If the parent does, Texas can enforce the support order against those assets using what's called in rem jurisdiction. The term in rem jurisdiction refers to a tribunal's authority to take action against property located within the state, even if the owner of the property is not subject personally to the court's authority. In our example, a tribunal in Texas has in rem jurisdiction over any real estate or bank accounts the non-custodial parent has in Texas. If the state does not have jurisdiction over the non-custodial parent or her assets, or if one-state remedies are not appropriate, the 4D agency providing services to the custodial parent must use the interstate 4D case referral process under UIFSA and federal regulations. The initiating agency providing services to the custodial parent will send an interstate 4D case for support enforcement to the responding agency where the non-custodial parent resides or has assets. Here in the diagram, Texas is initiating an interstate 4D case seeking registration and enforcement of the Texas order to Arizona, where the non-custodial parent resides.
This slide lists the required federal documents that must be sent by the initiating agency on a two-state case to register and enforce a child support order. Again, we have the Child Support Enforcement Transmittal Number 1, the Child Support Agency Confidential Information Form, and the Letter of Transmittal requesting registration and enforcement. In addition to the federal documents, UIFSA requires that the initiating agency send 2 copies, including 1 certified copy of the order to be registered, as well as any modifications of the order. And UIFSA also requires a sworn or certified statement showing the amount of any arrearage. Just as with an interstate 4D case to establish a support order, the interstate 4D case to enforce a child support order is received at the responding agency's central registry. The central registry will check the file for completeness and request any additional information or documentation needed, send the acknowledgement form back to the initiating agency, and send the case to the local office. After this occurs, the responding agency has a choice on how to proceed. In an interstate enforcement action, UIFSA requires the responding agency to consider using administrative actions to collect support without first registering the order for enforcement, if it's appropriate to do so. The most common type of administrative action is income withholding order. UIFSA provides the non-custodial parent the ability to contest administrative enforcement and if the parent does so, the responding agency must then register the order with the tribunal. The Interstate 201 training, which is next in the series, will cover types of challenges that a non-custodial parent can raise to contest administrative enforcement or registration of another state's order. If administrative actions are not appropriate, the responding agency may register the order for enforcement with the appropriate tribunal. Regardless of whether the responding agency decides to use administrative actions without registration or decides to register the order for enforcement, the responding agency is responsible for providing necessary services just as it would in an intrastate case, including initiating income withholding, monitoring the non-custodial parent's compliance with the order, sending payments to the initiating state's SDU, and identifying whether the non-custodial parent owes any arrears, and if so, taking enforcement actions as appropriate to collect those arrears, such as driver's license suspension. The initiating agency, in turn, distributes the payments to the custodial party. As mentioned in the beginning of the training, both the initiating and responding agencies may count the payments collected in their performance reporting. Let's look now at an Interstate 4D enforcement case. In the diagram, Texas is the issuing state and has the controlling order. The custodial parent and child reside in Texas, while the non-custodial parent lives in Arizona. The 4D agency in Texas can send an interstate 4D case to Arizona's Central Registry. Arizona's 4D agency will be the responding agency and must decide whether to enforce the Texas order administratively or whether to register the order with a tribunal for enforcement. If Arizona's 4D agency can locate an employer for the non-custodial parent, it may decide to issue income withholding to collect the support without first registering the Texas order. It will enforce the Texas support order in the same way it would administratively enforce an intrastate order and monitor compliance, identify any delinquency, and take appropriate administrative enforcement action to collect any delinquency, such as a state tax refund intercept, driver's license suspension, or bank lien. If Arizona cannot identify an employer for the non-custodial parent, it may decide to register the order for enforcement. Arizona will enforce the Texas support order, again in the same way it would enforce an intrastate order, by monitoring compliance and identifying and collecting delinquencies through all appropriate collection tools. And before we move on to modification, are there any questions on interstate enforcement?
So this is Diane. At this point, in the interest of time, to make sure we get through our very last subject in this training, we're going to skip this round of questioning, but hopefully we'll have time after we do modification to take one last round of questions. So next slide. The last topic for Interstate 101 training is modification. As we've discussed, when a tribunal with jurisdiction establishes a support order, it is the controlling order. Next slide, please. That initial controlling order will set the duration of the support obligation, which can be modified only if allowed under the issuing state's law. The controlling order will be in effect until the order is fully complied with or modified in accordance with UIFSA. Remember, modification of a controlling order is not allowed, except as provided by UIFSA. This rule keeps the one order at one time UIFSA basic principle. It also ensures that the state with CEJ modifies the order. Under UIFSA, spousal support is not modifiable in any state except the issuing state. While UIFSA permits the tribunal in the issuing state to modify spousal support, that litigation does not fall within a 4D agency's responsibilities and therefore will not be covered in this training.
The first UIFSA modification rule is that if either parent or the child lives in the issuing state, modification can only occur in the issuing state, and the issuing state retains CEJ, and no other state will have the power to modify the order. The only exception to this rule is when the parents consent to another state modifying the order and assuming CEJ. That consent must be filed in a record with the issuing tribunal. And further, the state assuming CEJ must have personal jurisdiction over at least one of the parties or be the state where the child resides. It's important to note that CEJ is based on where the parties reside at the time the modification request is filed. The second UIFSA modification rule is that if neither parent nor child lives in the issuing state, modification cannot occur in the issuing state. The issuing state no longer has CEJ to modify the order. The only exception to this rule is if the parents consent in a record or in open court for the tribunal of the issuing state to retain CEJ to modify its order.
Another UIFSA modification rule applies when the parents move out of the issuing state and now live in the same state, and the child does not live in the issuing state. In that case, the new state where the parents live may register and modify the order. Once the order is modified, the state becomes the issuing state and assumes CEJ for any future modification. Anytime a state modifies an order and assumes CEJ, UIFSA requires the party obtaining the modification to file a certified copy of the new order with the tribunal that issued the original order. The final but very important UIFSA modification rule applies when neither the parents nor child live in the issuing state and the parents now live in different states. In that case, the parent who wants the modification must seek modification in a state with personal jurisdiction over the other parent. That usually means seeking registration and modification in the other parent state. This is called the play-away rule and is a basic UIFSA principle. The rule is intended to eliminate the undesirable effect of a race to modify an order to obtain home field advantage.
The registering tribunal applies the laws of its state to determine whether the order should be modified, the procedures that must be followed, and whether there are defenses to a modification request. Further, the tribunal will apply its child support guidelines to determine the new support amount. Remember that under UIFSA, the registering tribunal cannot modify any aspect of the child support order that is not modifiable under the law of the issuing state, and this includes the duration of support. For example, if the duration of the initial controlling order is 18, once the non-custodial parent has fulfilled that duty of support, the tribunal in another state with a longer duration cannot impose a further obligation on the parent. On the other hand, if the law in the original issuing state provides that a tribunal may order support to continue past the age of 18 if the child is disabled, a tribunal in another state with jurisdiction to modify under UIFSA may modify the support order just as the issuing tribunal could have when it had CEJ to continue support past the age of 18 if the child is disabled. Also, once the registering tribunal modifies the order, that state assumes CEJ and will be the only state with the power to modify that order until it loses CEJ. But what if the registering tribunal does not modify the order, maybe because the legal standard for modification has not been met? Under UIFSA, if the tribunal does not modify the order, the state does not assume CEJ. The federal intergovernmental forms listed on this slide apply to a request to modify a support order of another state and include, again, the transmittal number 1, the Uniform Support Petition, the General Testimony, the Child Support Agency Confidential Information Form, the Personal Information Form for UIFSA Section 311, and the Letter of Transmittal requesting registration. Under UIFSA, the initiating agency must also send 2 copies, including 1 certified copy of the order to be modified, including any modifications of the order. In this illustration, Arizona has issued the controlling order, and the non-custodial parent resides there. The custodial parent and child live in Texas and have asked the Texas 4D agency to review the case for a modification because the non-custodial parent received a promotion and raise at work. If a modification is requested, it needs to be filed in Arizona because Arizona has CEJ and one party still lives there. There is an exception to the rule, however, which is if both parents file consent in the record with the Arizona tribunal for Texas to modify the order and assume CEJ. And here we see Texas as the initiating agency and Arizona as the responding agency. Texas would ask Arizona to modify and enforce its order.
So here, this scenario is different because New Mexico is now the issuing state and no one lives there. The custodial parent and child live in Texas, and the non-custodial parent lives in Arizona. Let's assume that the non-custodial parent lost his job and applies for 4D services in Arizona. Even if no one lives in New Mexico, the parties can consent in a record or open court for New Mexico to continue to exercise jurisdiction to modify its order. The more likely scenario, however, is that the Arizona 4D agency will need to send a request for registration and modification of the New Mexico order to Texas under the playaway rule. Here, Arizona is the initiating state and Texas is the responding state, and the order is registered for modification in Texas. Texas will apply its child support guideline to determine the new amount of the support order. Once it modifies the order, the Texas tribunal assumes CEJ. Under UIFSA, however, duration is governed by New Mexico law as it issued the initial controlling order, and therefore, Texas cannot set the duration of the support obligation according to its laws. Remember that UIFSA requires the party seeking the modification, here the Texas 4D agency, to send a certified copy of the new order to the tribunal in New Mexico. If the order is not modified in Texas, possibly due to the fact that there is not a significant change in the monthly amount of support due, Texas does not gain CEJ in the case. So we have a few minutes for some questions on interstate modification or any topic covered today, but I first want to point out that after the webinar, all registrants will receive a training evaluation. We hope you will complete it, and you are welcome to include any additional questions in the evaluation response. You also can send your questions to OCSC at the email address listed on the slide.
And operator, would you please again open the lines?
Yes, thank you. Once again, to ask a question, please press *1. And we do have some phone questions when ready.
Go ahead with your first phone question.
Thank you. Ashley Ledbetter, your line is open.
Yes, ma'am. We did have a question that actually came up recently, and this would pertain to the 311 form, the personal information form. The form says that it is to be filed with a tribunal, but then it also says the form is not to be filed in a public access file. And we were I guess our confusion comes in when we file this into the court record, it then becomes a file that can be accessed by the public. Are we expected to redact information, or
that's the responsibility of the
4D agency, or is that
or the courts actually, because that's where it's been filed.
Diane, do you want me to answer that one?
Yes, please.
We've had a lot of discussions on this. Actually, technically, it is the court's responsibility to file that where it is not in an open public file. And if that isn't happening, we really encourage your 4D agency to have some communication with your courts about how to do that. because technically, unless nondisclosure has been requested, the information needs to be provided to the court and the other party.
And may I ask one more question about the forms, please?
Okay.
We've had a lot of complaints that the forms are the fonts. Some areas on the form, your font is very small, and in some areas it's very large.
You know, I think that's a time when I would call the central registry in the other state and let them know that, because the central registry probably doesn't see the forms, and maybe that state can work on it. It's not something that OCSE controls, what font they use.
It's in the OMB version of the forms, the form field, the PDF that you can fill in. When you type into the field, the font gets smaller and smaller and smaller.
The more you type.
From the OCSE site.
I don't know that there's any way to change that, unfortunately.
Jeanette, this is Ann at OCSE. We will take a look at that, and we'll report back at the next training session on 201.
Okay.
Thank you.
Thank you.
Our next question comes from Jean Owens. Your line is open.
Hello?
Go ahead.
Okay. Can another state refuse to process a UIFSA packet if the copy of the child's Social Security card and birth certificate are not included with it?
That's a very good question. The required forms are listed on the matrix, but states do have, according to their own court procedures, sometimes additional requirements. It would be interesting to know what the state is saying that those documents are required for. So if you had that information, then I think that would help better inform whether or not it was, something that the state truly required in order to process the incoming case. Jeanette, what do you think?
Yes, I would answer similarly. I think that there are certainly cases, I don't know why the Social Security card would ever be required, but certainly sometimes if paternity is an issue, the court will want to see the birth certificate to ensure that there's not someone else listed on the birth certificate. So my philosophy on this is when you can provide what they're asking for, do it. Mm-hmm. And if you absolutely can't, then contact that other state and have a discussion about it.
And then I have one other question. I ran into a problem where the other state, it was a third-party case. The custodian was the grandparent of the child, and we were, trying to establish child support and paternity. The other state was requiring a signed affidavit of parentage from the biological mother, who was not a part of the case. And I kept telling them, we have no contact with her. She's not part of this case. And they're like, well, the custodian is the biological mother's parent. So can't you get that? I'm like, no, I can't get that. I've requested it from the biological mother. She's not responding. And my case has just been stalled because of this.
Well, one of the things that we tried to do with the new forms was to kind of solve this issue by giving the paternity affidavit a place for someone not a parent to fill it out and be the petitioner. Mm-hmm. I think the best thing if you're really having problem is either to talk to, first of all, if you haven't, to talk to the central registry in that state, and if you need to get your OCSE regional office involved in the case.
Okay. Thank you.
And I think we are about out of time. We want to go on to a couple of other slides here before we finish up. So these slides have the important reference materials that we... Hello?
Hello?
Yes, can you still hear me?
I can hear you.
Okay. I had an odd thing with my phone. If the participants are still on, these slides have listed the important references materials that we talked about in this training and provided the hyperlinks to those materials.
So next slide. Okay, and those are more references. And final slide, please. So this concludes our Interstate 101 training. We have 5 more Interstate training sessions for you in September, October, and November this year, and January and February of next year. Registration for these events will be available 2 to 3 weeks prior to the dates listed on the slide, and we hope you will be able to join us for these trainings as well. Finally, OCSC will post the recordings and PowerPoints, including trainer notes, from all of these sessions on the OCSC website for your future use and to share with colleagues who may not have been able to attend any of the sessions. Thanks, everyone, and have a great afternoon.
Thank you for your participation. You may disconnect at this time.